Louise, could I just triple check with you? It looks to me as though everyone we are expecting is in fact present. Is that right? Fabulous.
It is, yes.
You were muted, but I can lip read.
Can you? That's good. But yes, everybody's here. We only have one participant.
Marvellous. Are we yet live streaming?
You're all good to go. It's all
We
live.
are.
Yeah.
It's live. Right, okay, thank you. Very good. In which case, then it is 2 o'clock, and so I resume the further hearings of this examination of the North Hertfordshire Local Plan 2011 to 2031. For those of you who haven't met me before, I'm Simon Barclay. I'm a planning inspector and a chartered town planner, and I've been appointed by the Secretary of State to hold this examination into the soundness of the local plan. So I'm assuming that everyone has read my guidance notes. There are 2 of them, my general guidance note and my very special guidance note about the virtual hearings. I'm not going to go through all of that, but by and large, if I can ask everyone to have their microphones switched off throughout the proceedings, apart from obviously when you are speaking. My preference is for people to join and to stay on with their cameras switched on, but if you don't wish to do that, then that is also fine. Yeah, just so that you're aware, because it can be slightly disconcerting. My camera is slightly lower than the screen on which I have people's faces displayed, so I'm aware that it might appear as though I'm sort of looking off vaguely into the middle distance or into the sky, but when I'm doing that, I am in fact looking directly at you as you appear on my screen before me, and as well as in real life physical hearings, I will quite often have my head down because I'm making notes. So, but I will try and keep as much eye contact as I possibly can. So what I want to do now is just do some very brief introductions so that we are all clear about who's who. So I'll do a school register style approach to this. So if I sort of call your name, if you could just say hello and introduce yourself briefly, and then I'll move on. That would be great. Thank you. So first of all, I have Ms. Ormsby.
Good afternoon, sir.
Ms. Daly.
Good afternoon, sir.
Mr. Smith.
Good afternoon, and for Ms. Wigley, I'm Nigel Smith, Strategic Planning Manager at North Herts. And
Mr. Jarman.
Good afternoon, sir. I think we've met previously at the examination in Malden a couple of years ago. I'm from Opinion Research Services, and I've been responsible for completing the assessment of need for travellers in North Herts.
I have a vague recollection of undertaking that examination.
I think it was at a very nice country club with a golf course.
You recall correctly. And I have also Mr. Braybrook.
Good afternoon, sir. I'm Chris Braybrook, and I'm the I'm the Senior Compliance Officer for the Council.
Okay, thank you. And I said that those are the participants on the Council's behalf. And for Codicut Parish Council, Miss Wigley.
Good afternoon, sir. Yes, I'm Council instructed by the Parish Council.
Thank you. Good afternoon and welcome all. Is there anything that are there any questions, or is there anything that I need to pick up on? Any housekeeping items or anything that I need to pick up on before we move on? Very good. In which case, then let us turn directly to Matter 25, new land proposed for allocation, the proposed gypsy and traveller site at Danesbury Park Road. and that relates directly to two modifications put forward by the council, being MM139 and MM385. So if we go then to issue 20, yeah, sorry, I probably should have said for Ms. Wigley's benefit in particular, I haven't produced any sort of separate agendas or anything like that. So I'm simply, well, hopefully quite simply anyway, working from my matters and issues paper. So if you do have that to hand, then that's probably going to be beneficial.
Sorry, can I just check? Is that the I've seen the council's Matter 25 statement, which I think follows that, doesn't it? So is that basically the agenda we're using? So 25.1A is the inclusion of the new area of land for allocation necessary for soundness. Is that what I should be looking at?
Yeah.
Yeah, that's great.
Yeah, that's right. I think equally, if you have the council statement to hand, I think I think you rightly identify that the council's statement follows the same sequence of questions, and does repeat them. So yeah, okay. So yeah, indeed, as you say, yes, the first question is the inclusion of the new area of land for allocation necessary for soundness? And if I can put that to the council first of all, is that, I'm not sure who to look to in the first instance. It's you again, is it, Mr. Smith?
I'm afraid so. I will kick off and give you an overview, but obviously Mr. Jarman has the specific expertise on the needs study if needed, and Mr. Braybrook's slightly more familiar with the sites themselves. This particular modification, as you'll probably recall, arises out of the original Matter 12 hearing that we had in 2018. And the Parish Council were present at that session where we examined the needs study and its methodology, and set out to you our position that the plan as submitted was unsound because it no longer made adequate provision to meet gypsy and traveller need. And as a consequence of that, without re-rehearsing that whole hearing session, you asked us to prepare these main modifications. We brought together all the evidence supporting that in the homework you set us out of that session, which is ED 149. Obviously, you've got a matter statement in front of you. We're satisfied that, as of today, the assessment of needs remains robust, as do the site-specific exceptional circumstances, which we'll come on to. The families remain resident on the site, and the detailed criteria related to this site can also be met, and evidence by way of update. And this is jumping slightly. At paragraph 9 of our statement, we make reference to an application having been submitted and being under consideration. And in August this year, the council granted a 2-year temporary planning permission, effectively to tide the site over pending the outcome of this examination process.
In August this year?
Yes.
Okay, so the necessity then for the main modification stems, does it, from the question of need and supply?
Correct, yes.
Okay, I think we'll come on to supply a little bit later on, I think, under question C, which is about the justification.
Yeah.
So, if I can hold that there for a moment. Yeah, I have reread the needs study. I can't for the life of me remember what it's called now. So I read it just this morning, reread it just this morning. But in any event, you know what I mean. I've reread that this morning, but just for the benefit of the examination, then what does the council say the needs are, just in headline terms?
We've identified an overall need for 12 pitches over the plan period, of which 4 are to be met by this site. Two of the pitches of those 4 is an immediate need, and the other 2 arise later in the plan period.
So 4 on this site, 2 on this site are immediate need. Yeah. 2 on this site are for future needs later on during the plan period. Is that
That's
right?
correct, yeah.
And Ms. Wigley, were you going to pick up on the issue of need?
Yes, sir. Yes, I have a number of points on the issue of need, and particularly in relation to the robustness of the study and whether that sufficiently demonstrates need. Can I just check? You've got the Parish Council's letter dated 26th of February 2020, which I think is the statement on this hearing, for this hearing.
In front of me, yes.
Thank you. Yeah. So there's just a number of, well, there's 3 general points of approach and then 3 detail points I'd like to make about the need statement. The first is that in the need statement itself, and I'm taking this from ED 149, which appends the need statement, I think, at paragraph 3.2 of that, it quotes from the PPTS, the government policy 2015, and which requires that in assembling the evidence base, you should pay particular attention to early and effective engagement with both the settled and traveller communities, and should cooperate with other authorities and work collaboratively with neighbouring local planning authorities. So 2 points arise out of that. Firstly, contrary to that advice, it appears that the GTAA includes no engagement at all with the settled community. And you'll have seen in the February 2020 letter that my client contradicts a number of the conclusions from the need statement. Secondly, sir, you'll be aware, I think, that this site in particular is very close to the boundary with Welwyn Hatfield Borough Council. And less than a mile from Danesbury Park is the Four Oaks gypsy site in the Welwyn Hatfield site in the Welwyn Hatfield administrative area. And we know that from the need statement that there's been no collaboration, no updated collaboration with local authorities, no discussion with them as to the situation there. And that's specifically stated at 3.7 of this GTAA, the updated GTAA. No further stakeholder engagement was completed. And then in 3.8, there's a list of local authorities that ORS has recently completed or is currently completing GTAAs with, and none of those listed include Welwyn Hatfield Borough Council. So we say there's a lack of robustness in relation to both of those aspects, the lack of engagement with the settled community and the lack of collaboration, in particular with Welwyn Hatfield. So in relation to the evidence base, this has been primarily on the basis of interviews. That's the methodology that's relied on. And paragraph 3.3 of the study emphasises the need for a full demographic study of all occupied pitches, interviewing gypsy and traveller households, including those living in bricks and mortar accommodation, and considering the implications of the new government policy. And you'll be aware that obviously the new government policy issue is the change in definition of travellers to exclude those who have ceased to travel permanently. Now, the interviews that were undertaken are very limited, and you can see that from figure 6, which is on page 25 of the study. If you just bear with me a moment, I'm just going to get it to hand. Yes, figure 6 shows that there was, and the surrounding text, that in terms of the Pulmer water site, there were 2 interviews with bricks and mortar residents, but no interviews at all with any of the gypsy and traveller households, none at all. Only 1 interview with the manager or owner of the site. And that seems to be where all the information has come from. And we say that that's unreliable and not robust. And on the basis of that interview data, such as it is, there's a conclusion in relation to future need, which isn't based on any demographic application of percentages, even though there's a huge amount of information about growth in this report, all of which is irrelevant because none of it's used as a basis for predicting household formation. Household formation is predicted on the basis of the existence of children on the site, 4 children on each site, 2 of whom are identified to be reaching adulthood and giving the need for 2 further households, 2 further pitches. Again, it's not clear where that information comes from, other than possibly the owner of the site. And we say that's not robust. It's also contradicted by local information, as we state in our letter dated 2020. So the other, and this is really quite an important issue, a very important issue, paragraph 7C of the PPTS emphasises the need for a robust evidence base to establish the accommodation needs. And the methodology set out in the document is quite clear. 3.37, the current need is addressed by looking at households on unauthorised developments for which planning permission is not expected. And then, sorry.
Just bear with me a moment, just my note taking can keep up.
Yes, of course, sir. I'm sorry, I don't want to give you risk-take.
Sorry, you were pointing to paragraph 3.37.
Yeah, of the GTAA again, sir. Yeah, 3.37, which I think is on page 20 of the document.
You said it addressed what? Sorry.
Sorry.
You said it addresses what?
Yes, current need. It addresses the methodology for looking at current need assessment. Yeah. And there's a number of components of current need there set out. The first is households on unauthorised developments for which planning permission is not expected. And then there's 3 other elements: concealed, doubled up or overcrowded households, households in bricks and mortar wishing to move to sites, and households in need on waiting lists. Now, sir, the only component of current need relied on in this GTAA is the first, i.e. households on unauthorised developments. And the way that's assessed is explained at 6.14, which let me just scroll down. So I haven't printed all this out. I'm trying to be environmentally friendly. 6.14, and just get the page. 6.14 discusses how this has been assessed. So it's the outcome from the household interviews, and in this case there weren't any in terms of Pulmer water site. So it was the interview with the owner of the Pulmer site was used to determine the status of each household against the planning definition. And it states only those households that meet the planning definition in the ORS were able to determine that they travel for work purposes and stay away from their usual place of residence when doing so, or have ceased to travel temporarily, form the components of need that will form the baseline of need in the GTAA. So only those who meet the definition. And so then you'll see that the need has been later on in the following paragraphs from 6.14 discusses the need that's been found. So there are in figure 7, there's one household on a private site, that's at Pulmer Road, meets the planning definition. and one on the residential caravan site. Those are both authorised, so they don't meet the component of current need because it's only households on unauthorised sites. And then there's 2 on unauthorised sites that meet the planning definition listed there. But of course, we have a lot more than 2 to 4 households. And the reason for that, the reason we have 10 to 12, including the future need, is because at 6.18, analysis of the household interviews completed at the private site indicated that there is a current need for the 6 unauthorised pitches as a result of the lapse of the temporary consent in March 2017. Now, so the 6 unauthorised pitches are not occupied by traveller and gypsy households. So it is absolutely baffling how they can comprise current need. And I say that, and that's very clear from figure 6, which is on page 25 of this document. Within figure 6, you've got unauthorised pitches, Palmer Water, 6 pitches, and they weren't interviewed, and the reasons they weren't for not interviewing them were 6 non-travellers. Very clearly states they're non-traveller households. And so I query how those 6 non-traveller households can make up a component of current or future need, because the methodology clearly sets out that they have to meet the definition of gypsies and travellers in the PPTS to form a component of that current need. And that obviously is a very significant element of the need relied on by the council, which is 12 in total. And I say that's a very clear hole in the need assessment. So the other issue on the results of the need results is the questions you raised following the last hearing, in particular in relation to the capacity on the northern part of the site. And so just if you've got figure 6 to hand still, that would be the, I think, if I'm understanding this correctly, the first line of the table there, which is the 12 pitches at Palmer Water, which are authorised. And you'll see that there are 9 non-travellers recorded there, 2 vacant and 1 where there was no contact possible. Now, so the 9 non-travellers, you asked why they couldn't, those pitches couldn't be used for travellers. And the council set out answers to those questions, which are also form part of ED 149. And they refer to the planning permission having been amended in 2017. This is for the 12 pitches. And I had a look into this, and it looks like that planning permission was issued on the 30th of January 2017. That permission clearly includes a condition saying that the site shall not be occupied by any persons other than gypsies and travellers, as defined in Annex 1 of the Planning Policy for Traveller Sites. And so, as you'll recall, of course, that definition now excludes travellers who have ceased to travel permanently. But the council then rely, in saying that there's no capacity left here, on the fact that those 9 pitches are occupied by gypsies who previously led a nomadic life and are all retired. Now, so that leads to 2 questions in my mind. Firstly, it's unclear exactly where that information has come from and whether it's up to date, because all we know is that only 1 person, the manager of the site, was interviewed in relation to that part of the site. And so it's also worth noting that the site has separate parts that are physically separated. So it's not clear the extent to which there will be good knowledge as to the features and the characteristics of the occupants. And it's not clear how reliable or the extent to which that might be self-interested. But also, sir, of course, if they are nomadic and if they've are no longer leading a nomadic life and are all retired, and have ceased to travel permanently, then they no longer meet the definition. And strictly speaking, they don't meet the condition on the planning permission. And they could be, that planning permission could be enforced against, that condition could be upheld. And those families, or those couples, if they're retired couples, could be required to move and to take up residence elsewhere in, for example, the residential part of the site. So the council, whilst they've given you information in response to your question, it is not, in my submission, it is not satisfactory explanation as to why that part of the site could not be used to accommodate any outstanding need for travellers. But as I say, the need in any event that has been identified is very much undermined by the fact that the 6 unauthorised pitches are not occupied by travellers in any event. So it's very unclear how those pitches can give rise to any current need. So those, I think, if I could just check my note, those were the main points I had on the assessment of need. And for all those reasons, we say that the need is simply not robust and does not justify an allocation, a further allocation under the policy.
Okay. Are you stopping there, Ms. Wrigley?
Well, sir, I'm stopping in relation to. I think I've said quite a lot. So, in relation to the GTAA, those are the main points. I mean, obviously, if there's response, I'd like to come back if I have any further points on the responses. But those are the main points that I wanted to put forward in relation to the robustness of the GTAA at this stage. I mean, so the only other point was, if I could just make it, because it's a general point, obviously that the interviews, such as they were, that were undertaken, were carried out in July 2017. We haven't seen any further evidence of any or updated evidence of the council having looked into any current situation in relation to those sites. And my client's been told that the council don't tend to enter the sites or talk to the residents. So we just don't know what the up-to-date position is. And so I think that concludes what I wanted to say for the moment on the need assessment. Thank you.
Thank you. Yeah, if I can pick up just on that general point, first of all, before I ask the council to reply to those points, I have to say I am looking for a pretty clear response to the points that Ms. Wigley's made. But just one general question to kick that off. That is the point about, well, the GTAA is dated July 2017. Are GTAAs particularly sensitive in terms of their up-to-datedness?
If I could ask Mr. Jarman perhaps to pick up the points on the methodology.
Yes, good afternoon all. There's a lot to take in. I was of the impression that the discussion on the soundness of the assessment methodology was discussed at the previous hearing session, but again, happy to pick up on some of the issues. I'll start with the final one first. In some cases, there are differences in demographic circumstances for assessments that may be out of date, so to speak. But these tend to be areas where there is a lot of activity in terms of gypsy and traveller sites, planning appeals, planning applications, large numbers of sites, sites where there are private rental going on, public sites where there is a turnover of pitches. In North Hertfordshire, there is a very static population living on essentially two sites, the Pulmore Water Wexford site and the site that we're here to talk about at Danesbury Park Road. We have not spoken to the residents since the assessment at Pulmore Water, the sites there, because my understanding was that the allocation had been agreed in the policy as proposed for submission and as was examined in the previous examination sessions. But we have spoken with the residents at Danesbury Park Road. Recently, we spoke with them on the 17th of November just to confirm their circumstances. We spoke to them on the telephone, and they also gave us a WhatsApp video tour of the site to show us what had been going on since we previously visited them back in 2017. As I said, that was on the 17th of November, and the site was very clearly set out as the most recent aerial photography suggests, in terms of the units on the site, the residents on the site. The people that we spoke to on the WhatsApp call were the same people we spoke with back in 2017. You could see that the children that we'd identified had grown up a couple of years. And they told us of recent works that they have completed on the site to prepare foundations for a new amenity block, for example, should anyone want to question the validity and the date stamp of that meeting. But we're 100% confident that the Connors family, Mr. Connors and his brother, wives and 4 children, are still firmly resident on that site, and that there is nobody else living there and has been nobody else living there. So that covers the engagement issue. How would you like me to run through this, sir? Have you got any other particular questions based on what Miss Wigley has raised?
Yeah, I know that we have covered this, at least in part, at previous hearing sessions, but nonetheless, I think it bears revisiting. You say that covers the engagement. It does in relation to Danesbury Park Road, but there is also the point about engagement in relation to Pulmore Water. You're on mute, Mr. Jarman. Sorry,
it is very often the case, sir, that in our Gypsy and Traveller assessments, and for those that are not aware, ORS have now completed about 170 since 2015. The use of proxy information has been accepted by inspectors both at examinations and appeals in lieu of being able to complete interviews face-to-face with the individual residents. Travellers travel. It's their lifestyle in the majority of cases, and whatever time of the year you visit traveller sites, there are always households that are not around to be interviewed. But in the case of Pulmore Water and Wexford, we did have a site owner, stroke site manager, who had an encyclopedic knowledge of all of his tenants, many of whom were friends and family. So whilst we weren't able to interview people face to face, I am comfortable that the proxy information that we got off Mr. Connors at Pulmore Water is an accurate reflection of all of the tenants that were living on his sites at the time. Including full demographic details to enable us to project future household formation.
Okay. What about the question of engagement with Welling District Council? It's District Council, isn't it?
Unfortunately, despite repeated attempts, and North Hertfordshire isn't the only local authority in Hertfordshire that we've completed assessments for. We've done Dacorum, we've done Hertsmere, we've done East Herts, North Herts, St Albans. In none of these have we been able to elicit a response from Welling Hatfield in relation to a stakeholder interview. It's not just as part of this study and the previous assessment for North Herts that we were unable to get a response from a planning officer. It's been a common picture across all of the assessments that have involved Welling Hatfield as a neighbouring authority through duty to cooperate engagement.
Okay, so then, Mr. Chairman, that's to say that you've contacted them, but that they haven't been forthcoming.
We have contacted them on numerous occasions for numerous studies in Hertfordshire, seeking a stakeholder interview to fulfil the duty to cooperate elements of the GTAA.
Yeah, I'm not talking about the duty here. But I get the point that you've done quite a few GTAAs in this part of the world. That's fine. But if we can just focus on this one, this specific one, just so that I'm absolutely clear and I don't get something wrong. So for this GTAA, you've contacted Welling Hatfield, but they simply haven't got back to you.
Correct. Yes.
Is that a problem?
I don't think it's a problem, to be honest. There's a very close-knit community of planning officers across Hertfordshire and surrounding areas that deal with gypsy and traveller issues. And in the main, they are aware of issues going on in other local authorities. And they would have raised particular issues if there was any problem going on with Welling Hatfield, because part of that stakeholder interview with neighbouring authorities is a discussion about relationships and issues with their own neighbouring authorities, and Welling Hatfield would have come up in those conversations if there were any particular issues.
On Ms. Wigley's point about there having been no engagement with settled communities,
I would dispute that. We did complete interviews with 2 settled households, which is clearly set out in the report. And if you go to paragraphs,
Mr. Drummond, if you just bear with me, just one moment while I catch up. You said there, I think, that you've spoken to 2 settled households.
we spoke with 2 settled households. The census recorded 19 households in North Hertfordshire that identified as gypsies and Irish travellers who live in a house or flat. We went through a rigorous approach to try and identify households in bricks and mortar. This is set out in paragraph 3.17 of the GTAA report. We worked closely, as well as asking people that we interviewed and organisations representing travellers. We spoke at length with the Hertfordshire County Council Gypsy and Traveller section, and they identified anybody who was on a waiting list for a public site anywhere in Hertfordshire that lived in North Hertfordshire and sent letters out to them. We worked with the Traveller Education Officer in Herts County Council who distributed flyers to all known households in bricks and mortar that she engaged with. We spoke with Heartgate, which is a traveller organisation representing travellers across Hertfordshire, and they weren't aware of anybody in bricks and mortar, living in bricks and mortar in Hertfordshire, North Hertfordshire, that they have been engaging with. We spoke with friends, families and travellers. We spoke with North Herts Environmental Health to see if they were aware of any gypsy and traveller households in bricks and mortar. And we engaged with North Herts District Council Housing Department to see if they were aware of any households and asked them to pass on our details. Nobody, apart from the 2 households that we interviewed, got in touch with us. And from my experience, having completed over 170 such assessments and been questioned on numerous occasions that there is a significant need for households in bricks and mortar to be living on sites, I simply dispute that based on the work that we attempted to engage with these people and the fact that none come forward. That suggests to me that there is no further need from households living in bricks and mortar.
And the engagement there that you've just been telling me about, Mr. Jarman, is that set out somewhere?
Yes, it's in paragraph, it's on page 16 of the GTAA. If you're looking at the same version I have, there's a section entitled Engagement with Bricks and Mortar Households. Paragraph 3.15 it starts with.
I have that. In terms of future needs then, Mr. Jarman, how did you establish that?
Future need is from new household formation, from younger children living in households. We were able to identify the demographics of all of the gypsy and traveller households in North Hertfordshire, and we used that information to calculate the likely future formation for children. I believe that due to the very small number of children living on sites in North Hertfordshire, we were not able or not in a position to apply a percentage rate of formation, which is very often an area of challenge in arenas such as this. But we used evidence that we've collected across traveller assessments that we've been completing since 2007 to suggest that where there are small numbers of children, you would expect 50% of those children to form a new household of their own and stay in an area, and 50% of households to form and move to another local authority in terms of pairing off. So we're not having an argument here about the 3% or the 1.5%, because we're dealing with such small numbers of children that you need to make a judgment based on the age and demographics of those children.
So if you bear with me a moment, I'm just attempting to skip seamlessly through the GTAA and failing. Yeah. So on the point then about current need, and Ms. Wigley pointed us to paragraph 3.37, which sets out the various components. Ms. Wigley says that households on unauthorised developments, unauthorised sites, is the only component of the four there that this GTAA goes on to examine. Is that right?
That's correct. There were no concealed or doubled up adults or families living on any of the pitches. There were no households in bricks and mortar wishing to move to sites, and there isn't a waiting list for public sites, and nobody on the waiting list for other sites in Hertfordshire has expressed a wish to live on a site in North Hertfordshire, even if there were to be one.
Okay. If we can go then to the points that Ms. Wigley made about figure, was it? Excuse me, I think it's figure 7. I think it is. Yeah, and the point about unauthorised pitches being occupied by people other than Gypsy and Traveller households, and actually it's figure 7 and figure 6, I think, that play into this particular point. And the question about how the 6 non-traveller households form a component of current need. Have you taken? I mean, is that the way that you've approached it?
When we spoke to Mr. Connor, the owner of Pulmer Water, Wexford Park, he made it very clear that he has family members that are away travelling, and that ultimately those pitches are for members of his family to move back to. So therefore, we took the view in the assessment that as they had planning permission previously based on family need, were not currently being occupied by members of the family, but there's every intention of family members to move back to those pitches, that they should be included within the assessment. Because otherwise this would have caused an issue further down the road and potentially increase the need unnecessarily.
Sorry, forgive me. My fault entirely. I'm sure I didn't quite follow that.
The unauthorised pitches that have been included as components of demand within the assessment were granted temporary planning permission, and that permission lapsed in March 2017. At the time of the assessment, they were occupied by non-travellers. But Mr. Connor's intention is that he has family members who are away travelling at the moment, and that those pitches are for members of his extended family, as well as his immediate family who just aren't on the site at this time.
Right, so it was being temporarily occupied by non-travellers, whilst travellers who normally occupy were away travelling. Is that what you mean?
that was our understanding following the interview with Mr. Connor. And it's common that families will often apply for planning permission for more pitches than they need at that precise point in time, because they know that they have future needs that will need to be met for their family. So you often get sites where there are unimplemented pitches that have been granted permission for children in the future. And you do sometimes get instances where you have had family members living on sites who have gone off to cut their teeth and do their 2-3 years travelling, as younger travellers tend to do before they come back and settle down.
Yeah, just one point of very minor point of clarification. We are using the term Pullmore water. I noticed that in this figure 6 it says Pullmore water / Wexford Park. Is that just simply the same place? Is that the place that we've been referring to as Pullmore water generally?
If you look on page 23 of the assessment, there is a plan which essentially shows that the Pullmore water Wexford Park. I'm not 100% sure which bits are called which, but it is essentially a site that is subdivided into 3 distinct areas based on their planning status. Chris has just had to pop out, but I think Chris would be able to explain that more fully, or maybe Nigel would if need be. But I've seen that as a single site divided into 3 areas based on their planning status.
Yeah, I mean, I have not been on this site, but from from that aerial photograph, it does appear to me, as you say, that it is one site that is divided into 3. So am I right then in thinking that part of that site, or 2 bits of it or whatever, are referred to as Pullmore water and the other is Wexford Park? I just don't want to be confused when I see numbers against names of places, if you see what I mean. Because on here you see on figure 6 you have on Pullmore water / you have an entry for Pullmore water / Wexford Park under the private sites heading, under the bricks and mortar heading. Under the unauthorised pitches, that relates only to Pullmore water, and I'm not quite sure which is which. I'm just trying to work out whether I need to know.
I don't think you need to know, sir, but say I'm sure that Chris would be able to clarify that point. But as I said, I've taken the same view as you have from having visited the site and looked at the aerial photograph, that it is one site. It just has different planning constraints on different parts of it. One is a residential caravan site with no restrictions on who can occupy it. One had planning permission temporarily for gypsies and travellers that lapsed in March 2017, and one has planning permission for 12 pitches in a bungalow.
Okay. And I'm not sure if this one's for you, Mr. Jarman, or someone else, but Miss Wigley's point about the 9, where have they gone? the 9 non-travellers on Poolmore Water. Is this again? This is the first line in the table at figure 6, I think, which records there being 9 non-travellers on the Poolmore Water / Wexford Park site. Miss Wigley's point being, well, you know, perhaps they ought not be there really, and that potential capacity ought to be through condition very likely made available for people of the gypsy and travelling community. Is that again because the gypsy and travelling households that would normally have occupied those units were off travelling? Is it the same point that you just made, that there were non-travellers there on a temporary basis at the time?
I've just seen a note from Mr. Braybrook, who's still had to pop out, and his understanding is that those pitches have an existing use granted as a caravan park. I can't comment on that further without him being here, but they were not travellers that don't meet the planning definition. They were non-gypsies and travellers living on those pitches at the time.
If I can direct you to, it's in ED 149, which is the homework we did after Matter 12 the first time around. I think this was discussed at the original hearings. There's quite a complex planning history on this site with the sort of overlaying, as Mr. Jarman's alluded to, permissions, temporary permissions, existing uses, and they're all laid out at the back of that document as to which parts of the site those permissions apply to. So as Mr. Jarman says, I think where it talks about 9 non-travellers there, as Mr. Jarman has alluded to what Mr. Braybrook's told you, that's the bit of the site that has a lawful use as a residential caravan park.
One thing that...
So if you just bear with me, just one moment, please, Mr. John. So then, Mr. Smith, that's to say, is it, Mr. Smith, that there isn't it's a caravan park without any particular restriction limiting occupation to gypsies and or travellers?
That's correct. So in Appendix 2 of ED 149, there's a list of all the applications that have been granted, and as was referred to, there's one on there. I can give you the reference if you want, but essentially, yes, the council granted a lawful development certificate for the use of the site as a residential caravan site.
Right, okay. Right, okay. Thank you for that. Yeah, Ms. Wigley.
So thank you. I'll just take those points in reverse order, if I may. First of all, the point about those 9 non-traveller households, I have to say, I think the council's just plain wrong on that from their own information. First of all, it might help if we just look at the aerial photograph on page 23 of the GTAA, the labelled area photograph, and you'll see on that page there are basically 3 broad areas of the Poolmore Water, whatever else it's called, site. And the one to the west on the left-hand side is the unauthorised 6 pitches. The one to the south-east on the right-hand side is the residential caravan site with the certificate of lawful use. And then the top part of that to the northeast is the 12 pitches and one bungalow with permanent planning consent. So those are the 3 distinct areas. And then if you relate that back to figure 6, and somehow I've just messed up the way my viewing here, but on my screen, but let me just, figure 6 is on page, my scrolling's gone wrong, so just bear with me a moment. Figure 6 is, on page 25, I think.
Yeah, I've got that.
Yeah, so you'll see you've got the 3, the sites are separated out separately. You've got the private sites, which is the 12 pitches, and then residential caravan site is a separate category there. And then unauthorised sites, you've got the 6 pitches in the penultimate line. Those are the three categories in Palmer Water, or other than the bricks and mortar households. And so it's simply not right that the 9 non-travellers were in the residential caravan site. And so if you don't believe me, it's the council themselves in their response to your note. This is an appendix to their to this ED 149. It's towards the back of the document. I don't have the page number to hand because I printed it out separately, but their own answers to your question, where you asked for a note explaining the scope of planning permission granted for use to the north of the Palmer Water site. So that's the one for the 12 pitches to the north, and discussing whether the permission allows for removal of the 9 non-identified non-travellers from this site. If the need cannot be accommodated, why not? And clarifying the scope of the use of the authorised by the CLUD. You'll see there that the site for the northern part is subject to the planning permission, which was amended in 2017, and that includes the condition which says that the site shall not be occupied by any persons other than travellers and gypsies defined in Annex 1 of the PPTS. And of course, you'll recall, as I said earlier, that now excludes gypsies and travellers who've permanently ceased travelling. But then in the paragraph at the end of that section, before C, it says the gypsies on this part of the site previously led a nomadic life and are all retired. So there are therefore no inhabitants that could be removed for this site. All other planning permissions on the site, save the CLUD, are conditional on occupants meeting the definition. And the definition. So the CLUD is a separate issue, sir, completely separate issue from the 9 non-travelling households. The 9 non-travelling households are explained by the council as being retired. Now, we don't know where that information's come from. And in any event, as I said before, retired gypsy and travellers who have no intention of travelling in the future are contrary to the condition on that planning permission. So in relation to that, I just say the answers are just simply unsatisfactory.
Can we just pause there for a moment, because it seems to me this is a matter of fact, isn't it?
Yeah.
I just get this sort of sinking sensation that the more we discuss it, the less clarity I have. I noted you're nodding there, Ms. Ormsby. I don't know.
Well, I think that's right, sir. I mean, obviously, we haven't actually had any notice of any of these points that have been raised. All we've got is a letter that was written by the parish council. So we are having a little bit of a discussion in a vacuum at the moment. But I'm with you. We also seem to be well off the mark of the points that you wanted to talk about, which is Danesbury Park. We seem to be on a completely different site now. Yes, it's important that clearly you have a clear view on it all. I have to say I'm getting a bit confused by it all now. But I think probably the best thing to do is to discuss the way forward. I think it might be helpful, actually, if perhaps Miss Wigley could write these points down. I mean, I've got a careful note of them, but at least we have a bit of notice as to the points that she wants to raise, and then we can maybe respond to them. If there are issues of fact, it becomes a bit difficult to deal with now if nobody knows the answer. Or it looks like the answer might be unclear.
Yes, I mean, I kind of get the sense that the answer may well be in here somewhere, but it's putting together.
Yes, well, it is. It is.
A jigsaw.
It is, and well, we did come here to discuss Danesbury Park, and we now seem to be focusing significantly on formal water. You know, I make no complaints about that, but
it plays into my question A, doesn't it? That's why.
Yeah.
So yeah, that it was fairly inevitable. But either way, I need to have that.
Yes.
I need to be absolutely clear. And
yeah, of course, sir. Yeah.
And making, I think, the question is, at least in part, about making the link between the facts on the ground and the planning permissions, the certificate of lawful use, and the link between those things, and in particular, I think figure 6 in the GBA, so that I can understand why we've got these numbers that we've got. If that does it make sense?
Yep. No, it does. What, Ms. Wigley, I know you put your hand up. Don't worry. We'll let you have a say in a minute. It's really just how we take this forward, because clearly you do need clarity. I have to say I'm not sure I followed this perhaps as clearly as I might have done. And it's really a question of how we move on. How do you want to deal with this, sir?
Well, I am rather distraught.
Well, please don't get distraught. That's we can't have our inspector distraught. What I wonder is, would it be helpful if, and I don't want to be unfair to Ms. Wigley, she's raising the points, they need to be resolved, of course. Would it be helpful if perhaps the parish council set out their points so that we're clear as to what they are, and we can provide a response, and of course if they then want to put any reply in relation to that, they can. But at least so you've got this information in one place where you can see what the position is, in order to try and reach resolution rather than obfuscation. Would that help? I'm just trying to think of a way through this now.
Yeah, it would. Obviously, I want to remove from, even though this is an examination of soundness, there's a dispute here, and it's a dispute about facts, and I need to know the facts. I wonder if some kind of, well, I'm tempted to say a statement of common ground, but I'm not sure that's quite the right thing. Yeah, I think something from the, I mean, you know, this is a bit off the cuff, obviously, so, you know, if you can think of anything better, I'm open to suggestions. I'm really reluctant to ask for another note from the council, but one that clearly sets out the situation. I mean, and again, this might just be drawing stuff out of that's already in ED 149, but presenting it in a clearer way, but so that I can see precisely what's been allowed where, and obviously anything relevant that I need to know about those permissions, i.e., you know, any restrictive conditions that are relevant here, is going to help me, but also an explanation of the link between that and the figures that we see, the numbers that we see in figure 6, because I'm not sure now whether the 9 non-travellers that we see are retired, or whether those were temporarily occupied by non-travellers, or precisely what?
And indeed where they are, and where they are, or where
Well,
they are.
Yeah.
Yeah.
So something that can tie all of those facts together, so that I've got a clear picture of what's what. Now, so I mean, if the council can put that together, how we then go forward with that, well, might depend in part on what the picture is, on what that actually reveals in my mind.
So can I just make a few points in relation to that? I think it's slightly unfair to say that this session was only about Danesbury Park, because clearly the whole foundation of the need is based on Pulmer water as well. That's the basis of the GTAA. And in our own letter in February 2020, we said that we were not satisfied that the GTAA was robust, that the interviews were robust. You know, so it's not really fair to say that we've you know, these are entirely new points, whilst the details new. Perhaps.
If I can just stop you there, because it was always clear in my mind that we were going to be talking about this today, because the first thing I've got to ask myself in relation to Danesbury Park is whether or not the inclusion of that site is necessary for soundness, and that point probably almost entirely hinges on what the situation in Pulmer water is.
Exactly.
And unfortunately, I'm still not as clear as I need to be on that.
Yeah. Well, sir, and I think you helpfully asked these questions. The council's already given a note, and yet they're not prepared. They haven't come here prepared to answer questions on that note. And this is the hearing following that note. It seems a bit unsatisfactory. I mean, the reason I'm slightly exasperated is obviously the parish council has instructed me and expended resources in instructing me for today. And if there's then going to be a further round, it does sort of prejudice their position somewhat that this can't be thrashed out today. I mean, I certainly would like to be able to have the opportunity to make the further points I need to make, particularly in response to Mr. Jarman, what Mr. Jarman's made, the points he's made in relation to other points. But I totally understand, so you need the accurate factual position. And obviously it's been pretty contradictory today, the information you've received. But I would like the opportunity to continue with my oral responses in any event today on the points that Mr. Jarman's made.
Yeah, certainly. I don't mean to abandon ship here and now. It is that, unfortunately, the very first step, which is a critical step, and will affect all of the others, as you'll understand, will have to, for today, remain unanswered. But what we can do, of course, is continue the discussion on the basis that, well, on the basis of as matters of fact, the council has got it right, so that we can go on to the Danesbury Park specific issue, so that we can talk about that today.
So yes, but I would like the opportunity to respond on the other need points that Mr. Jarman's responded to, which aren't necessarily.
Well, I want to do that now, and I think that's going to be helpful, I think, because it might also reveal other areas of uncertainty that it's going to be useful for the council to clarify. Of course,
yeah. So shall I continue then, sir, on the points, the responses to those points that have been responded to? Yeah. So in light of the discussion that's just been had, I'll move on from the 9. The mystery concerning the 9 non-traveller households on the private sites at Pulmer Water, and the next point, going backwards in terms of Mr. Jarman's responses, is the 6 unoccupied, sorry, the 6 unauthorised pitches at Pulmer Water, which are recorded in Figure 6 as occupied by non-travellers. but then form the basis of the current need, six pictures for the current need. Now, so that's now responded to by an assertion by Mr. Jarman that Mr. Connor told him that those 6 pictures were needed by unspecified traveller families who were apparently travelling at the time, whilst their pictures were being occupied by non-travellers. Now, sir, there's nowhere that is explained in the GTAA. It's just not set out anywhere. So all we're relying on now, if you're to rely on it, is Mr. Jarman's comment today, not backed up by any evidence. And in any event, even if that's correct, it's just Mr. Connor's assertion that his family are travelling elsewhere. It's a very flimsy basis for need for an allocation in a local plan. And in response to your early question, Mr. Jarman confirmed that there's been no follow-up interviews at Pulmer Water since 2017. And his justification for that was that, oh no, there's a very static population at Pulmer Water. I don't know on what basis that assertion is made, particularly given that he's now relying on the fact that, oh, some of these 6 families were away travelling, so weren't there at all. And it's never been checked that they've come back or that they're occupying the site now. And the need, a very substantial proportion of the need is based on those 6 non-existent families. And so that application, that temporary planning permission that expired in 2017 hasn't been renewed. As far as I know, and the council may have other information, but I checked their website, there's no application to renew that's been made. So it's very, very flimsy information to justify 50% of the need relied on in relation to those 6 temporary pitches. So on the point about engagement with the settled community, the lack thereof in conflict with the PPTS, and you'll recall the paragraph there which advises that there needs to be engagement with the settled community as part of the evidence base. Mr. Jarman's response to that is on an entirely different point. His response is about contacting gypsy and traveller households in bricks and mortar accommodation. And he relies on paras 3.15 to 3.17 in relation to that. And he says there were 2 interviews of bricks and mortar households, which is right. There were 2 interviews of bricks and mortar households on the Pulmer Water site. Those are the only interviews with bricks and mortar households. And so quite plainly, that's not the settled community that is envisaged by the PPTS. It's gypsy and traveller families in bricks and mortar households. It's not the settled community. There has been no engagement with the settled community, with any local residents who may have information and do have information to contradict the mere assertions, which form the whole basis of this need, of one person on the Pulmer Water site.
What do you say, or who do you say the settled community is then, Ms. Wrigley?
Well, so I say it's the community who live, who are not gypsies and travellers, who live in households in the local area, and who may have information as to the comings and goings of households on the gypsy and traveller site. And that's clearly the community envisaged by the PPTS. That's what settled community means in my submission. It doesn't mean gypsies and travellers living in bricks and mortar accommodation. So it's an inadequate response to that. So in relation to engagement with Welwyn Hatfield Borough Council, I have to say I'm very puzzled by Mr. Jarman's response to that. He said, in response to your question, that he did try to contact Welwyn Hatfield Borough Council in relation to this GTAA, and they just didn't respond. That's entirely contradicted by the GTAA itself, which says at 3.7 that they didn't engage with the other local authorities. And I'm just sort of baffled by that. I mean, you'd think if there had been an attempt to engage and that hadn't been responded to, that would have been recorded in the GTAA, but the opposite is recorded.
Just bear with me a moment. 3.7.
3.7, yeah, stakeholder engagement. 3.7 and 3.8, sir.
Okay.
Thank you. And sir, in relation to future need, my understanding is this is based on an assessment of 4 children on each of the 2 sites. So 4 children on the Danesbury Park site and 4 children on the Pulmer Water site. And of those, it's considered that there are 1 or 2 who need who will likely gain an age where they need to develop a new household. Now, I understood Mr. Jarman's evidence as relation to the Danesbury Park site, but there's been absolutely no update or engagement with anyone on the Pulmer Water site since 2017. And as I've said repeatedly, the only interview that was done then was with the manager or owner. So the projected future household need at Pulmer Water is entirely unreliable because, well, first of all, it was unreliable in the first place, just 1 interview. And secondly, so there's been no attempt to assess the current position since 2017. And contrary to Mr. Jarman's assertion at the beginning of his responses, it's clearly not the case that this is a static site in terms of the population there. And the residents, local population, have said that, you know, as far as they're concerned, there's different information as to who's living there and what children are attending the schools and the like. So I mean, I have to say it's flimsy in the extreme, the basis of the need in this case, even irrespective of whether or not there's that issue of the 9 households either in a CLUD or on a private site where they could be removed under the condition of the planning permission, which is what the council say in their own note. So those were my responses on the need points that Mr. Jarman made. Thank you very much.
Okay, thank you. I think what I'll do, just want to be sure, Ms. Wrigley, I think it's probably a good time to sort of take all of your points on the question of need, because I'll ask the council to give me any additional response that they think might be helpful to me at this stage.
So
we'll move on to question B.
Yeah, no, so I think in terms of need, which obviously it overlaps with very exceptional circumstances. So, obviously I rely on these points in relation to exceptional circumstances, but I mean, those are really my points on need and capacity in that respect. It's those 6 points. So the engagement with settled community, collaboration with neighbouring local authorities, lack of robust interviews, unreliable future need, the 6 households on the unauthorised site, and the capacity in the northern part of the site. So those 6 points are.
Is this for you? Well, yeah, just picking up on those points, just any final reply from the council. But one thing that I do want a comment from the council about is this question about the settled community. This was the PPTS point. Don't know if that's for you, Mr. Smith, or for Mr. Jarman, or someone else.
I think it's for Mr. Jarman in relation to whether or not one should be engaging with the settled community in relation to the activities that are going on a potential site.
To be honest, having probably been through 30, 40 local plan examinations and numerous appeals, this is never an issue that I've had raised, either an appeal or an examination. We do caught the views of the settled population through the stakeholder interviews, through charities involved with bricks and mortar households. In some cases, we do a engagement, an online engagement with members of parish, town and community councils. It wasn't part of this study, but I certainly wouldn't want for each of my GTAA studies to want to pick all the residents living within a nominal distance of each Gypsy and Traveller site and ask them what their views on Gypsy and Traveller sites are, because it wouldn't help in terms of providing an independent, robust assessment of need for travellers.
Yeah,
And
you might not want to, but so you have to forgive me. I've about 2 minutes ago, I accidentally closed my copy of the my electronic copy of the PPTS. So I don't know if someone can tell me precisely what it says, just to remind us all.
I have it in front of me if it helps. Would it help me if I read it out, the bit that I'm relying on? It's under paragraph 7 of the PPTS, policy A, paragraph 7, headed using evidence to plan positively and manage development. It says, in assembling the evidence base necessary to support their planning approach, local planning authorities should, and then paragraph A, pay particular attention to early and effective community engagement with both settled and traveller communities, brackets, including discussing travellers' accommodation needs with travellers themselves, their representative bodies and local support groups. And then there's B and C, but in relation to the settled community point, I think it's only A that I need to read out.
in terms of that, we have always relied on engagement with the settled community through their advocates, including town, community, parish councils and elected members where appropriate. We've already found in terms of the allocation site that the points made about the site being occupied by non-travellers that were made from members of the travelling community are wholly incorrect. So how would we be able to rely on any other people who say that what we found on the site is wrong and they found something different?
So just in response to that, I mean, obviously figure 6 shows a very large number of non-travellers living on the site, which does seem to accord with the parish council's position. And in any event, so in making an independent and robust assessment, as Mr. Jarman refers to it, he's relying on one manager owner, and there's no record in the GTAA of any collaboration or discussion with the parish council or any other community body. I'm not necessarily suggesting that every individual household in the vicinity should have been approached, but some engagement with the settled community should have taken place, and there was none here at all.
Just bear with me one moment, please. Just so I'm clear, Mr. Jarman, what has been the engagement with settled communities in this case? If I could just ask, you do. I can understand why you do this, so it's no criticism, but you do say things like, we always rely on engagement through, and well, maybe you do, but I just need to be absolutely clear that we're talking specifically about North Hertfordshire here and not somewhere else. So just for the avoidance of doubt that I currently have in my mind, what has been the engagement, the early and effective, I think, engagement with the settled community in North Hertfordshire? My apologies, Mr. Jarman, you're on mute.
I think that's going to be a new term in the dictionary next year. As you can see in the methodology section, because this was an update of a recent study, there was no engagement done whatsoever, other than through the attempts to engage with the bricks and mortar community. We'd completed comprehensive interviews with officers. We discussed issues with officers at the time, and there hadn't been any fundamental changes. And as you can see in the next paragraph, 3.8, we've completed recent studies in an awful lot of the neighbouring areas, and no issues were raised in relation to North Hertfordshire that led us to feel that we needed to do a further round of stakeholder engagement to support this update. If I'd entered this session today on the basis that there had been a request to revalidate the need from the two sites in North Hertfordshire, as we have done for the site at Danesbury Park Road, I would have been able to do that and would have been far more prepared for Miss Wigley's lines of questioning, which have come completely out of the blue to me.
So could I just say on that point about it being an update, I've also had a quick look at the 2014 GTAA, which is HOU 10, and as far as I can tell, but Mr. Jarman maybe will be able to correct me if I'm wrong, there wasn't any engagement with the parish council or the settled community when that study was undertaken either. But I may be wrong on that, but I just raised that as a query. I mean, in our submission, it wouldn't be adequate if in any event, because there should have been engagement in the update also. But I don't think there was any engagement with the settled community when the 2014 study was done either.
Unfortunately, I can't comment on that because I wasn't working for the company at that time.
Well, so the document is in the inquiry, in the examination documents at HOU 10, so perhaps we could verify that. But as far as I can tell, it doesn't record any engagement.
Yeah, for my part, it's been a while since I read the original GTAA, so I don't recall what it says on that point. Okay, is there anything else that the council would like to add? And I think I'll then take a short break and then move all the way on to question B. Do I take the silence as no, Mr. Smith, you're going to leave it there?
Correct. Yes.
Okay, thank you. In which case I make it 3:33. Adjourn the hearing to resume at 3:55. Thank you. Oh yeah, I should say, during the adjournment, if you can switch your, keep your microphones off and also switch your cameras off unless you want us to all see what you're doing during the break. Thank you. Okay, it is now 3:55, and so I resume the hearing. Yeah, just before I move to question B, yes, just on this point about paragraph 7 of the PPTS, I think, well, my understanding is we've established that there hasn't been any engagement with the settled community as part of the production of the update. And Mr. Jarman says, well, yes, it's an update, but I don't know whether that occurred in respect of the original GTAA for reasons I understand that he didn't work for ORS at the time. But Mr. Jarman did say that in terms of that type of engagement, that we, by which I'm assuming he means ORS, always rely on engagement through with settled communities through advocates of those communities, and he gave us as an example of that parish councils. I don't know, Ms. Wigley, if you've been told anything about that from Codicut Parish Council. I've had a very brief look through the 2014 GTAA. And this is on the basis of a very quick look. As I mentioned before, it's been some time since I looked through the 2014 GTAA in any detail. On the face of it, it doesn't appear to me that it mentions engagement with the settled community or particularly parish councils, and that may or may not be the case. I will need to look through that rather more thoroughly than I've been able to during a short break. But if it is the case that there hasn't been engagement with settled communities of any kind, is that what does the council say about that? Is that a problem in relation to in relation to consistency with national policy?
So just before, would you like me to answer your first question about whether I know from the parish council whether there was any engagement? Because I did just take instructions during the break, and I'm told that they're 99% sure that they weren't contacted in relation to either of the 2014 or the later GTAA.
Okay, thank you for that. If that is the case, is that a problem? I don't know if that's a question for Mr. Smith.
I probably defer to Mr. Jarman in terms of he's got the expertise of the level of engagement that's carried out with these kind of assessments usually.
So perhaps I can say something here before Mr. Jarman says anything. It's my understanding that the point that Ms. Wigley is on is that whether or not engagement in the community might shed some light on the activities in relation to a site, and whether or not there is in fact a need for the travelling community to have particular pictures on a site. So I think it simply goes to whether or not you consider that the evidence in relation to the need is robust or not, and whether or not engagement with the community might have shed some light on that. That, as I understand it, is the point that Ms. Wigley is on. So it all goes back to whether or not the evidence in relation to the need for a particular site is robust in the light of the assessment that has been undertaken and the basis upon which the conclusions in relation to need have been reached.
So
it's not. So I'm so sorry, Ms. Wigley. I just so it's not determinative, but it's something that one needs to bear in mind in looking at the robustness of the overall assessment. Sorry, Ms. Wigley.
Sorry, I didn't mean to interrupt you, Mr. Hornsby. So I think that's a fair that's a fair summary of the kind of beef of our complaint about the failure to engage with the settled community, particularly given the flimsiness of the evidence that you do have in relation to the one interview. But sir, I just would make the further point that obviously it is, just as a matter of fact, from interpretation of fair interpretation of the PPTS, it is contrary to national policy, there being no engagement with the settled community. But the reason I rely on it in particular is as Mr. Hornsby says, that further adds weight to my complaints about the lack of robustness of the evidence base in relation to need.
Okay, thank you. I'm not sure that we're going to get any further on that, unless Mr. Jarman wanted to add something.
I think the only point I want to make is that, as far as I'm concerned, we have robust evidence of all gypsy and travellers living on these two sites, which we use to complete the assessment of need. And to reiterate the point that I have never, well, whilst it's correct or incorrect, the point about engagement with the settled community, I don't recall it ever having been raised at an appeal or an examination session before.
Okay, thank you. I'll go then to question B. Yes, hopefully we can get through this one rather more speedily than question A. Is the new area of land proposed deliverable? In particular, is it confirmed by landowners? Well, as I understand it, the occupiers own the land. Is that right?
Yes, that's correct.
And right, so presumably they have confirmed that. Evidence to demonstrate safe and appropriate access. You say on that point, I think that the Highways Authority has raised no objections. Is that right?
That's correct. And obviously in the granting of the temporary permission, Highways Authority were consulted and also raised no objections, bar the request for a condition on visibility.
And deliverable, having regard to the provision of necessary infrastructure and services and any environmental or other constraints. That's putting the issue of Greenbelt to one side for the moment.
Again, yes, and that's set out in paragraphs 11 to 15 of our statement, where we identify, as you say, notwithstanding Greenbelt, paragraph 14, there's a grade 2 listed building around 100 metres away, but that's very well screened, and there's a local nature reserve, but that's separated from this site by the motorway, which is in a cutting between the site and the local nature reserve. So yes, we consider it's deliverable. Okay,
Ms. Wigley.
So yes, if I could just make a couple of comments in relation to that. Just I note that in those paragraphs in the Council's Matter 25 statement, they refer back to the sustainability appraisal. So that's in the documents, that's set out in the Council's answers to your questions from last time, which is Appendix M12-2 of ED 149, and it's the pages towards the back of that document.
Yeah.
Did you want to get that to hand, or are you happy for me to just give you the points?
I've looked through it this morning, but if you bear with me.
Oh, I've now closed that document as well. Just bear with me.
Yes, I ought to say this is the first time I've attempted. Well, it's the first time I've undertaken a virtual hearing, but it's also the first time that I've attempted a paper light approach to hearing sessions.
No, I'm getting used to it too, which probably shows. I've printed some things off, but not everything, and it's sometimes, you know, scrolling can get a bit difficult when it. So it's.
Yeah.
I think it's right. Yes, it's.
I have that in front of me now.
Thank you. Actually, I've got it printed out, so I don't need to find it there. So just a few points on sustainability appraisal. The first point, actually, at the second page of that, under a just society, 5C, improve conditions and services that engender good health and reduce health inequalities. That's got a series of question marks next to it. And the comment is, site is adjacent to the A1M, so it's effectively a motorway. Potential impacts from noise and air pollution need to be mitigated. Now, so that's clearly the case when you've got a motorway right next to your site, and it's an open air gypsy and traveller site. There's no, whilst noise, I suppose, could potentially be mitigated by fence or something. It's unclear what assessment has been undertaken, if any, as to air pollution, and as to whether that really can be mitigated. As far as I understand it, it wasn't considered in the temporary, in the recent application and planning permission for the temporary permission. So I just flag that as a unresolved question in my mind at the moment. And so just in relation to other points on environmental protection under 3A, protect and enhance biodiversity. Justification for assessment, it says the site is mainly hard standing, apart from some trees on the site boundaries. That is the case, I think, now, but of course that was the product of unlawful development, that the construction of the hard standing and the trees have been cut down, or largely cut down. So it may, as a matter of fact, be like that, but of course, so there is advice that you know, applicants, I know this isn't a planning application, but it is perhaps material that those were that hard standing was introduced unlawfully, as far as I understand. But those were the only points I wanted to make on environmental issues beyond obviously the green belt, which I know we'll come on to in a moment.
Okay. Thank you. Is there anything else under question B? No, very good. In which case then on to C. Is the inclusion of the new area of land justified and appropriate in terms of the likely impacts of the development?
Yes, it is, again, for the reasons set out in our matters statement. Obviously, notwithstanding the points Ms Wigley's made around the overall assessment of need, which clearly we need to resolve and address outside of here, but given the first point here is the identification of a need for future gypsy and traveller provision. As we said, the approach to site identification, which again we looked at matter 12, where we've taken a kind of pragmatic approach to site ownership. That potential impacts have been considered as set out above, and that in the council's view there's no preferable deliverable alternative sites that allow that need to be met in an alternative fashion. And then obviously, as we set out in our statement, we then sort of lead into the exceptional circumstances points, which again reinforce that justification. But I'll pause there.
When you say, Mr. Smith, there are no preferable deliverable alternatives, are there any alternatives at all?
In the council's view, no.
And land for the accommodation of gypsies and travellers, was that included in a call for sites exercise?
I don't think we did a specific call for sites, but obviously in looking at other sites, so we've looked at large strategic allocations. I think the overall approach we've taken is that given this council has generally very small numbers, that we haven't pursued kind of public provision within, say, strategic allocations that you might see in some authorities.
Yeah, okay. So is that so? I'm looking at this is your Matter 12 statement, Appendix 1, where you set out a site selection flow chart.
Yes.
So step 1, identify need. Step 2, is the family currently accommodated on a site suited to their needs? And it's only if the answer to that is no that a call for sites is initiated.
Yeah.
So presumably here, the council has taken the view that the individuals concerned are accommodated on a site suited to their needs.
That's correct. Yeah. So we've gone down the yes arm.
You go down the left-hand side part of that flow chart, rather than initiating a call for sites, etc.
Correct. Yes.
It's wiggly.
So just 2 points on alternatives, if I may. The first is obviously that depending on your view as to need, in any event, we'd say that Pulmer Water is a suitable alternative if that's justified as an allocation. But that's a suitable alternative, and there's capacity there in light of the points we've made about need. So as to Appendix 1 of the Matter 12 statement, as you've rightly identified, there has been no general call for sites in relation to meeting the gypsy and traveller need. And it's quite plain from this flow diagram that it's not really plan making, it's just sort of arbitrary plan making according to where an individual decides to pitch up an unauthorised encampment. And then that's then taken forward by the council as a way of meeting that need. There's been no proper sort of plan making effort to address any needs by having a call for sites and by looking at in planning terms where would be best to locate these sites. So it is quite concerning that there hasn't been any proper assessment of alternatives or any call for sites in relation to this need, even if it exists, particularly obviously where you're trying to establish exceptional circumstances for greenbelt release.
Yeah, should Mr. Smith, the council's site selection process have been more proactive? Sorry, you're on mute, Mr. Smith.
I realised that at the one. I think we need to recognise it in this circumstance, in a way, how and why this update to the needs assessment came about. The needs assessment came about in response to the family at Danesbury Park Road moving on to that site and eventually appealing a planning decision, which led to the advice that we should update the GTAA, which obviously in turn identified their needs. And through our development management function, this is picked up at para 19 of our statement, the council has resolved that it wouldn't be able to sustain a refusal of planning permission for the current occupants at appeal, and effectively was going to sort of withdraw its opposition to that appeal, and then the appeal itself was withdrawn. So in that sense, it would seem to be a slightly redundant exercise to have then gone on to a site search and a call for sites for a family that are established on a site where the council's resolved there is a need and there are circumstances to support a permission.
Yeah, that council resolution, is that in relation to the temporary use of the site or the permanent use? No,
it was in relation to an appeal to a previous application on the site, and that application went to appeal, as I say, as a result of the updated needs assessment and advice in relation to that appeal. The council had to resolve that it wouldn't defend it. However, the appeal was never heard because it was withdrawn by the appellants before it reached that point. So it was kind of left hanging as a resolution in that sense. It's not.
They realised the council was friendly after all and didn't want to chance their hand with an inspector. Was that for the permanent use of the land or the temporary use of the land, though? I don't recall.
That was for permanent. I think Mr. Braybrook, can you confirm?
Oh, you're not on mute, and yet you are silent, Mr. Braybrook. I'm not sure what's going on there. Still can't hear you, I'm afraid. Oh dear.
It might be with your permission, sir, if Mr. Braybrook leaves the meeting and then attempts to rejoin, perhaps that will resolve it.
We did have this problem with Mr. Braybrook earlier, and we suggested that he leave and join, and it seemed to do the trick. So,
okay.
If Mr. Franklin could let Mr. Braybrook back in when he reappears, please.
Of course.
I wonder if we can put the point aside. Oh no, here we are. Mr. Braybrook is with us once more, although sadly his voice isn't.
If I given it's a point, given already we've got to do you a note on this, if it would be helpful, we can just clarify that point.
Yeah,
after the event and provide the references if needed, if it's an important point.
Either do that, or I don't know if you have any sort of back channel communication with Mr. Braybrook, in which case maybe he can let you know, Mr. Smith, what the answer to the question is. Either of those two ways, I'm happy. So, okay. Yeah, and Miss Wigley points to as well to Palmer Water being a suitable alternative. With the uncertainty about that, I'm probably going to need to wait, aren't I, for the council's note, just sort of clarifying what's what there before I can come to any conclusion on that, I think.
I think that'd probably be best, wouldn't it? In that we can set out the various permissions and numbers and who's where, and then you can inform a view.
Yeah, I think so, but I do nonetheless have Miss Wigley's point on the issue. And until we have that, I don't know that there's anything, Mr. Smith, that you can say that's going to be helpful to me in that respect.
Agree. I'm happy to proceed on to your next questions if you had no further.
Very good. Okay. Is there then anything else on question C? Marvellous. In that case, then I'll go to issue 25.2. So yes, and straight to A and the question of exceptional circumstances. Now, obviously, there are other things that come into play here, and it depends what I think about them, and that those things they need, and potentially as well capacity or lack thereof at Palmer Water. So there are some unknowns going into this equation. But yes, the sort of the unknown factor of those aspects to one side, Mr. Smith, the council says.
As you say, putting that to aside and on the premise that the council says the need assessment is robust and Palmer Water is an alternative, then yes, as we've said in our statement, we consider the exceptional circumstances do exist, both on the need points that we've already addressed in our statement in the general justification, and also at paragraph 18 there, which reflects what we put in ED 149 around the absence of a lack of 5-year supply, personal circumstances of the families involved, protection of characteristics, and the best interests of the children.
Yeah, just on the personal circumstances point, could you elaborate on that for me a little, please?
Yeah, I think that's similar to the issues raised through the application, the appeal around how they came to be on that site in the first place, and obviously their need for suitable accommodation.
So when we say personal circumstances, there is a need for suitable accommodation.
Mm-hmm.
Yeah, and when you say how they came to be on that site in the first place, what do you mean by that?
Well, my understanding, I think perhaps this goes to the point that Miss Wigley was making earlier about engagement or lack thereof with Welwyn Hatfield. Our understanding, or my understanding certainly, is that family came to be on the site because they moved off or felt they had to move off a site in Welwyn Hatfield and moved on to this location.
That's the site. Is it called the Four Oaks site?
Yeah.
And was that originally what do we know why they felt they had to move from that site?
I'm not sure I'm furnished with the facts to sort of give you the detail on that, but that's my understanding, is that they moved off that site, and there were specific reasons behind that, and that's how they came to be at the site on Danesbury Park Road.
I suppose what I'm getting at is whether that was a personal safety issue or whether it was something else entirely.
So could I respond on that issue? Just to draw your attention to the second page of the Parish Council's document dated 26th of February this year, and the fourth paragraph down on the second page, where the Parish Council information was that the family who were relying on a need to leave that site in, I think, the Welwyn Hatfield site, the Forex site, was that they had returned safely to that site. I mean, Mr. Jarman says that they're now back on the site in Codicut, but it's not clear whether they've been there all along. Certainly, the Parish Council's information is that they left the Danesbury Park site and went back to the Forex site for some time. And so, in any event, it's not clear what the current issue is, if any, to justify that being an exceptional circumstance or a personal circumstance amounting to an exceptional circumstance. So you just don't seem to have any evidence from anyone as to what those personal circumstances are and as to whether they still exist, even if they existed previously.
Does the council know anything about that from the planning application?
I think there was information submitted alongside the application. Certainly, I know when it went to committee, again, the personal circumstances of the applicants were cited as a material consideration in favour. To be honest, so it's as much. I mean, I don't know the full detail, but even if I did, I'd feel on slightly shaky grounds. Obviously, we're talking about personal circumstances of an individual family in a very public forum. I'm not quite sure how much I'm supposed to say or not to say, to be honest.
Yeah, I mean, presumably there's something in an officer report somewhere that's already in the public domain that may or may not give us any details about that.
Yeah, certainly the planning committee report just makes reference to the personal circumstances again, which is why I've kind of just repeated that basic point here.
Okay, I mean, you know, you'll understand why I'm asking this.
Absolutely.
It's something that the council says plays into the circumstances argument as part of the demonstration of I say personal circumstances, I mean to say exceptional circumstances argument. You're pointing to the personal circumstances, but I'm currently not clear what those are.
Yeah.
And the council well, in part, it depends very likely what amount of weight you want me to give to that strand of the argument in terms of how it feeds into the demonstration of exceptional circumstances. Clearly, the more information that you can give me, the better. Therefore, you know, if you want me to be able to give it more weight, then I would suggest that the council adds to its note that it's going to do for me. I mean, to be honest, that's a matter for the council to decide whether it wishes to do that or not.
Yeah.
Okay, sorry. So, yeah, Mr. Smith, you mentioned, I think, or if you hadn't, I'm sure you were about to, the point about need and supply, and I take that as a given. I think that's a fairly safe assumption. You point to the personal circumstances. I think you might have mentioned something else that I didn't note.
That's right. I just reiterate the points that were in our statement already, so you've got them in writing. Protection of the characteristics of the gypsy way of life and the best interests for children.
In terms of the best interests of the children concerned, presumably we're talking about them having a permanent place of accommodation.
Yeah, it's I found the paragraph in the committee report now, so you're right, this is quoting from a public document, a settled base to enable the children to benefit from local education and healthcare.
Okay. And what those things in combination, you say, amount to a demonstration of the exceptional circumstances necessary to warrant the removal of the site from the greenbelt.
Correct. Yes.
Okay, Ms. Wigley on this.
So just if you are concluding on exceptional circumstances, just a couple of points. First of all, obviously, accept in general terms, best interest of the children is potentially relevant, but there's no evidence that you have here that there's any particular need for the children to be on this particular site. And obviously, I refer back to the issue of alternatives and general need. So can I just check, when you said it's a safe assumption, need and supply, I think you meant it's a safe assumption that it's relied on by the council rather than it's a safe assumption that it exists necessarily.
The former being correct, yes, that it's relied on by the council, yes.
Yeah, because obviously I would reserve my position generally in relation to need and supply for the reasons you'll understand. So in relation to just on the document that is part of ED 149, which is it's Appendix M12.2, which is the council's note in response to your issues. There, the exceptional circumstances relied on include general exceptional circumstances, which are relied on, I think, in relation to general releases of greenbelt, so general housing site type reasons. So, for example, the intensity of objectively assessed needs, both within the district and across wider market areas, is one of them. So just a general point in response to that most of those, if not all of them, are plainly irrelevant to the Gypsy and Traveller site. They're just general background points that are relied on in relation to housing releases, as I understand it. So unless the council are specifically going to refer to any of those, then I'll just make that general point in response. So in terms of the protection of the characteristics of the Gypsy way of life, so in my submission, that doesn't add anything to need. I mean, obviously, the whole planning policy about meeting the needs of Gypsies and travellers is intended to enable the protection of the characteristics of their way of life and to enable them to have a settled base for travelling. It's not an additional exceptional circumstance. It's only, the meeting need meets that exceptional, it meets that objective if there is need. So if there's no need, then the protection of the characteristics of the Gypsy way of life is irrelevant and cannot be an exceptional circumstance.
So just to make sure I follow that line of argument correctly, you say to you that that point doesn't add anything to the question of need.
So yes, it's just it doesn't add anything to the exceptional circumstances relied on, because need encapsulates that. Meeting need for Gypsies and travellers encapsulates that objective.
Do you agree with that last point, Mr. Smith, or disagree?
I'd agree there's certainly an overlap there, isn't there? Yes, in meeting need on identified sites, we are in itself protecting the characteristics of the gypsy way of life.
Is there anything else that you wanted to say, Ms. Wrigley, on exceptional circumstances?
So I don't think so. I mean, obviously need is crucial to that, and you've heard my points on there being a lack of need, and I'm not going to repeat them.
Yeah, okay, thank you.
I should have just said the only other point to add to that, obviously, is the other side of the balance, that when assessing whether there are exceptional circumstances to release land from the greenbelt, you'd need to assess the degree of harm to the greenbelt by that release. And it's worth noting that the council that the parcel of land that this site is within a parcel of land which is recorded to make a significant contribution to greenbelt purposes. That's in the council's paragraph 20. And the council accept that that this site itself, paragraph 22, makes a moderate contribution to greenbelt purposes, and its release would therefore occasion moderate harm. So I'm not going to say anything more about that, but obviously that will be part of your judgment as to whether on the balancing exercise there are exceptional circumstances to outweigh that harm, and of course the in-principle harm of greenbelt release.
Yes. Naturally enough, it will, and that's why it's question B, which you have now moved on to fairly and squarely.
I was jumping the gun there, sorry about that. I was looking at the wrong document and thought we dealt with that.
No, so yes, Ms. Wrigley has taken us seamlessly onto question B. Do you take any point, Ms. Wrigley, in relation to the council's assessment of the contribution to greenbelt purposes as being moderate?
Well, so it's all a matter of judgment. I mean, I think my client would say that overall this site, particularly before the unauthorised development took place, made a contribution alongside the overall contribution of the surrounding area to greenbelt purposes, and was perhaps higher than moderate. I'm not going to argue over semantics about whether it's moderate or significant, but the parish council would emphasise that in their view, in its sort of pre-development state, it was certainly made a good contribution to the openness and greenbelt purposes.
Yes. Does that say that you are suggesting that I should consider the land as it was in its previous state, and particularly given that it's got temporary planning permission?
So I think it is material. I'm not saying you have to ignore the temporary planning permission, but it is material. That it has if for example you, sir, conclude that there isn't a need, and at the renewal of the temporary planning permission there were not a need, that it's quite conceivable that this site could be brought back into its previous state and could go back to making the contribution that it made previously.
Yeah, Mr. Smith, just for the avoidance of any doubt in my mind, the assessment of the contribution to greenbelt purposes being moderate, is that on the basis of the temporary use being there, or not?
No. I think it's possibly just important to clarify what the state of that site was immediately prior to the arrival of the current occupants. And my understanding, and Mr. Braybrooke can correct me if I'm wrong, is that a number of the trees had been removed. There was already hard standing on the site prior to the arrival. And I think it's, as we had in our discussion yesterday when we sort of walked through strategic parcels, sub-parcels and sites, clearly the council's view is that if you have a strategic parcel performing a certain function, then other areas within it can perform greater or lesser functions depending on their characteristics. So I'm content with our judgment that it's a moderate contribution to greenbelt purposes, and by extension, moderate harm should it be released. And we've put some justification for that in paragraph 21 of our statement. In that that parcel 6, that significant parcel 6, covers some quite distinct areas, and as we've said, that the visual and physical openness in this area is fragmented by the loose knit development in that area, whereas in other parts of parcel 6 you do have much more open fields and over the border and well in Hatfield woodland. So although it performs a function separating those the settlements in that area, then as you say, when you look at it at a site specific level and that site within parcel 6, then we're content with a moderate contribution.
I'm not sure if you answered my question about whether the conclusion of moderate, how that was arrived at, whether that was arrived at on the basis of its current use or...
No, effectively it was arrived at absent the use.
Okay. Yeah, okay. Is there anything else that you want to say on question B, Ms. Wigley?
So no, just to perhaps urge yourself, sir, to presumably you'll be visiting this at some point, to assess for yourself paragraph 20, the assertions in paragraph 21 on your site visit.
Okay, in which case then, unless there's anything else from the council, I'll go on to question C. Yeah, to what extent would the consequent impacts on the purposes of the Greenbelt be ameliorated or reduced to the lowest reasonably practicable extent?
Again, just as written in our statements at paragraph 23, I've got nothing further to add to that. I can read it out if it's of benefit.
Not to me, Ms. Wigley.
So my only point in response to that is, of course, screening may help in terms of visual effects, but the Greenbelt purposes aren't just about visual effects, it's about openness generally. So I mean, I understand it's to reasonable, practicable extent, but the very fact of development on the site reduces the openness of the Greenbelt. So that's a consideration. Okay. And again, sir, sorry, just to add, of course, if again, it's the extent of the efficacy of possible screening. I'm happy for you to rely on your judgment from visiting the area.
Okay, thank you. Unless there's anything else then on C, I'll move to D. would the adjacent greenbelt continue to serve at least one of the 5 purposes, or would the function be undermined by the land's allocation? You're going to point me to your statement, Mr. Smith.
Yeah, again, we've said yes, the adjacent greenbelt can continue to contribute to the purposes. Obviously, the assessment of the wider parcel shows that the land beyond the proposed allocation does already serve those purposes.
Is that an issue on which you take a point, Ms. Wigley?
So not specifically. Again, I'd just say for you to take that, consider that when you visit.
And E then, this is about the boundary being capable of enduring beyond the plan period. Mr. Smith, you're going to no doubt point me to your statement.
Correct, yes. Again, we've said it. We believe it is capable of enduring beyond the plan period.
Are you going to ask me to bear that in mind when I undertake my site visit, Ms. Wigley?
So, well, not so much in this. It's more an issue, I think, of need as well. That issue. We say that there isn't need for this site, and that there isn't need for this site during the whole of the plan period. So, not including this site would be capable of enduring beyond the plan period.
Yeah. Okay. F. Smith.
Yes, we've said that the proposed boundaries are consistent with the strategy. Obviously, the plan is seeking to meet what we stated, the identified needs for gypsy and traveller accommodation, and we've done so in accordance with the methodology in our statement.
Quickly.
So only to note that the sustainability appraisal identifies this as a big cross in the chart in terms of reducing unsustainable patterns of development and the need to travel by the motor car. So, I mean, it's a small point, but this isn't a particularly sustainable site in those terms.
Would you disagree with that, Mr. Smith?
It's outside any of our identified settlements, but obviously equally it's no more or less sustainable a location than the other residential properties located immediately around it.
Anything else on F? Very good. I'll move then to G. As the greenbelt boundary around the new land being clearly defined clearly using physical features already recognisable and likely to be permanent, does it avoid including land which is unnecessary to keep permanently open, apart from the entire site itself, Ms. Wigley?
Yes, and again, obviously, as per our statement, the site's bounded on 3 sides by highways, and the 4th side, which is across the southwest of the site. There's a requirement in the policy to secure an appropriate boundary, which in reality is there at the moment from how the site is laid out.
Ms. Wigley?
So I don't have anything to add on that.
Yeah. Okay, very good. Is there anything else to add in relation to this site before I move on to site SI1?
So could I just check the, because I'm not involved in site SI1. Could I just check what's going to happen from here. Is it that the council is going to produce a note and then the parish council will have an opportunity to respond to that?
Yes, that will certainly happen. I mean, some of it might, obviously my reaction, my response to that is going to depend on what it says, which might lead to a slightly different course of action. But certainly the note will be open for the parish council to provide written comment on.
Thank you. Well, so if you're moving on to a different site, I don't think there's any need for me to stay on the call. I'll just check whether you are and when you are, because I don't want to leave prematurely.
I'm not going to try and make you, Miss Wigley. No,
I'm grateful.
Of course not.
Oh, obviously, I'm very interested, but I have some other things to attend to.
Of that, I've no doubt.
Thank you, sir. In that case, I'll leave now.
Yes, thank you very much for your contribution, Miss Wigley. Thank you.
Thank you, sir.
I think that's the same for me as well, sir, if the council are able to confirm that I'm not needed for the next item.
Correct, yes.
Excellent. Well, let's touch base next Tuesday, Nigel, and thank you, sir, for a very interesting session.
Thank you for your contribution, Mr. Jarman. Thank you.
Thank you.
And similarly, Mr. Braybrook, if he wants to excuse himself.
Although he's not capable of telling us that.
No. It's a cheery wave.
Thank you for your attempts at contributing, Mr. Braybrook. Okay, yeah. I'll move then to site SI1. By and large, unless the council can think of any reason not to, I'm content by and large to deal with as I have it in writing.
Yeah.
Yes, happy with that. This is a very minor alteration. I think, as we've said, it's a strip of between 9 and 15 metres. It's a minor correction.
Yeah, my understanding, my recollection stroke understanding on this was that as originally, where's it gone? So bear with me a moment. Is that the plan's intention was that access to this site would be off of the I don't have the road number or name immediately to hand, but that it would be off the road that the site doesn't quite go up to.
That's correct. That's correct. Yeah, it was to be taken off the B656, and yes, you noted at the original hearings that the allocation didn't quite extend to the highway boundary, so there would, if not corrected, there would be effectively a small strip of green belt between the edge of the site and the highway, and you asked us to remedy that, which we've done.
So just for my note, that's the B. I know it's in your statement, but it's the B656.
656, yes.
Okay, well, as I say, I've read what I have in writing on that, and I don't have any further questions that I need to put. So unless there's anything else that the council wants to tell me, I will leave it there. Okay.
Thank you.
Thank you. Very good. In which case, let me just check. Yeah. I make it 4:55. I adjourn the hearing to resume on Zoom next Monday at 9 o'clock. Thank you.